Ready, start. The cause of action under Section 142B of the NI Act be said to commence from the date on which a defective notice against which specific objection is taken by the payee of the check is received. The clock of limitation start ticking on the lapse of 15 days from the date of receipt of such notice. These are the crucial questions that arise for consideration in this revision petition directed against a concurrent verdict of guilty, conviction and sentence. Para. To the skeletal fact first, the signature in the check is admitted. Handing over the check is also admitted. Transaction between the parties is not disputed. The check is for an amount of rupees 50,000. It bears the date 10/6/2002. The check was admittedly dishonored on the ground of insufficiency of funds. It was initially dishonored in June 2002. A notice of demand Exhibit D4 was issued on 29/6/2002. Exhibit P8 reply was given to the Exhibit D4 notice. In Exhibit P8, a contention was raised that no such check was issued at all. The complainant then realized that a very crucial mistake had crept into the notice Exhibit D4 sent by him. The check was actually drawn on the State Bank of Travancore, but in the notice sent by the counsel Exhibit D4, there was a crucial, grave and vital error in describing the check as one issued by the Indian Overseas Bank, Patrantitta. The complainant was faced with dilemma. He could proceed with the prosecution and request the court to ignore the error committed in the name of the bank on which the check was drawn. In alternative, he could disregard the notice Exhibit D4, the same being crucially and vitally defective, and presents the check again for encashment. The complainant appears to have been advised to follow the latter course. He presented the check again. It was dishonored again on the ground of insufficiency of funds. Exhibit P5 notice of demand was thereupon issued. This notice was duly received and acknowledged by the accused. It did not evoke any response. The complainant in these circumstances came to court with a complaint under Section 138 of the NI Act after scrupulously following the statutory timetable. The complainant examined himself as PW1 and proved Exhibit P1 to P10. The accused in Exhibit P8 reply took up a defense of total denial. When he received Exhibit P5 notice, he did not respond at all, but in the course of the trial, the petitioner accused took up a contention that the amount due to under Exhibit P2 check has already been paid and discharged under Section Exhibit D5 and D6 receipt. Exhibit D7 is a receipt for rupees 30,000 dated 4/11/2000. Exhibit D6 is another receipt dated 27/2001 for rupees 20,000. According to the accused, the amount due under Exhibit P2 check rupees 50,000 had already been paid and discharged under section. The accused took up a further contention that Exhibit P2 check was not issued for the due discharge of any legality enforceable debt/liability. It was issued as a blank signed check when the parties entered into the transaction as security for due repayment. Though the amount was repaid under Exhibit D5 and D6, the complainant did not return the blank signed check.